So exciting.
Right on cue, right on cue. Hold on, let me just do my part here. Good afternoon, everyone. Good afternoon. Just okay. Here we go. Gotta make sure that I get this out on social media, right?
Yes.
Yes.
All right, we're good. No extra audio here. And good afternoon, everyone. Welcome to Dollars and Cents. We are happy to have you. We're happy to be back again, just to enlighten the community about all types of things. And today is no different. Special shout outs from us, the team, myself, KP, Miss Billy Jane, Bolton, Rojo. Rojo. Oh my goodness, I always have a good time with that. She has been navigating us for the past few episodes through a whole bunch of information on how we can set not just ourselves up but our children up, right?
Right.
We are glad for that, and she's gonna be on here as often as possible, and we don't want anything to interrupt that.
So thrilled.
Yes, Miss Keisha is here from RTS Mortgage Financial Road to Success.
Road to success.
What? Let me back up for a second. Billy Jane, you are on social media, correct?
Yes, I am, and and my brand is PCAL Financial Group, Partnership in Creating a Legacy. So PCAL.
All right.
Yes.
And are you on Facebook, YouTube?
Facebook. Yeah, I do have a PCAL like YouTube channel.
Okay.
I gotta get all this stuff, but I do have some content out there. I've got my Facebook page. I do have some stuff on Instagram. So yeah.
All right.
That's definitely a work in progress, right?
It's okay. We're all navigating this, So yes, even me, who's been doing a little this and a little that.
Yeah.
And Keisha is also on Instagram. She's on Ion Mortgage, right?
Ion Mortgage, yep, and also RTS Mortgage Financial page on Facebook as well. Yes.
Okay.
All right.
Getting out there, putting yourself.
Yes. No, you're putting out your content regularly.
Yeah, that's it. We want folks to know that we got some powerful Black folks,
Yes, we do.
doing their thing. We have a special guest today. But I'm gonna read his bio. Mr. Kyle Corbin is here, right? He's gonna talk to us about some things, but let me just drop his bio first, and then we'll hear some more from him. Kyle Corbin, principal lawyer at Corbin's Law, provides legal services in the areas of real estate, wills and estates, corporate, commercial, intellectual property, and civil litigation. Kyle has gained a wealth of experience providing solutions and creating value for small businesses and individuals in the business service sector. It is my goal to serve communities and to provide the best representation in an industry that has historically been perceived as non-accessible to many. Mr.
Break those barriers, man.
Yeah.
Thank you for that amazing introduction. Yes, that's exactly what my practice is based on, really providing access to justice, access to legal services for many. And really kind of breaking down the barriers, as Miss Billy Jane said, in terms of the perception of access as well, not just the actual act of it.
So before we get in the room there, in our waiting room, we were talking about some of the things that we have been doing on here, and that would sort of bring you on to enlighten us a little bit more, right? But one of the things that we want to just sort of, want the audience to get a feel of who you are. Just give us a little bit of background about yourself. Are you originally from somewhere else? Or are you from Canada? Or are you schooled in Canada? Just a little, just to get to
Give
know
us
who.
a history, like a history.
Definitely. Okay. So again, as you've stated, Kyle Corbin.
Yeah.
I now have my own practice, Corbin's Law. However, I most recently am still affiliated with another practice, Mott Legal Services, where we do some criminal law and social justice work.
Yes.
So I work in that area as well.
Mm-hmm.
Background, I have educated in business.
Mm-hmm.
I have a bachelor's in commerce degree. I went to Ted Rogers School of Management.
Mm-hmm.
And somehow that took me into the area of law. But prior to that was kind of, the basis and the foundation for my experience in the business services sector, working with small businesses in marketing, promotions, basically business structure and strategy, that sort of stuff. I chose to expand that into the area of law. Went to the UK. I went to Leicester University, which is quite popular nowadays in terms of Canadian students trying to expand themselves into the area of law.
Right.
Got my law degree there, came back, worked a little bit, and as well as I got my master's in law as well at York University to kind of put that Canadian stamp of approval.
Mm-hmm.
Nice.
So I am born in Canada, but have a little bit of international experience, and I think it's in terms of our community, it helped me to really provide a foundation and basis for understanding the law as it is in the islands and the other countries to which we frequent. So I'm very versed in in the ability to kind of navigate, even though I'm only licensed in Canada, you know, to at least help navigate and provide that interjurisdictional support that our community sometimes needs. Um, as you stated in my bio, I mainly focus on the areas of wills and estates, commercial, corporate law, um, civil litigation, and anything that falls under those, like, for example, intellectual property and, business structuring, business startup, that sort of thing. So one of my main principles that I like to follow in terms of um, advising communities, anybody in terms of empowerment, is really the importance of small business and self-employment or building ourselves in terms of our ability to earn income and pass down generational wealth. That's one of my big cornerstones. So that drives me. That's why I'm here today, and I hope to assist in making sure that I can help you guys communicate that to people, as well as through the topics I'll be talking about today, how to keep that wealth and ability to earn within the family unit and pass down generationally as well.
You
I know Billy
you
likes that.
Well, yeah. I mean, he hit on generational wealth, income. There's a whole bunch of
Love it.
things that's that we've been speaking about, and we definitely want to enlighten the audience about these things.
Yeah.
Definitely.
I don't know, Billy, you wanted to lead with a question or comment?
Well,
Mhm.
okay. So what I would love to talk about is
Mhm.
what happens if you don't have a will. Because a lot of people are a little bit slow to get that stuff organized, and they don't even really think what's the big deal.
Yeah.
But
Yeah.
I would love for you to help shed the light on what happens if you don't have a will.
Yeah, a bunch of problems. Let's just put that conclusion there at the top.
Mhm.
Yeah, um, not having a will is something that and I understand a lot of people are in that situation where they don't, deal with their affairs while they're still with us. And unfortunately, what that does is creates a lot of problems for our family, our loved ones. It can facilitate even, contention between parties. And it really doesn't provide a structure for how things are supposed to be dealt with, tax wise, dealing with the government, um, taking care of dependents that may be left, how that generational wealth is supposed to be dealt with, all that sort of stuff. So, not leaving a will is something that really puts a damper in all that work we've put in through our whole life, and what we wish to do with it and maintain in terms of, kind of like I said, to keep the phrase I keep using, keeping that generational wealth and continuity through generations. Um, to answer your question even more specifically, it requires, if there's contention, you have to apply to the court to get the court to assign who's going to be dealing with the affairs in terms of executor. Um, it leaves a person to not understand really, or not have any assistance with who should be helping to deal with estate administration tax. There's so many things that leaving our loved ones without that guidance um, could create difficulty on. So it's definitely recommended to always have a will in place to sort out your affairs.
What can happen to children if there's no will in place? Let's say two, mother and father dies and children are just left. Is that a complicated situation, or it's just family takes over type of situation?
It really depends on the situation. In two scenarios, one being if there's not really a comprehensive estate, then it kind of is really just, okay, whoever can come together and really pitch in and make those arrangements, and based on pre-existing relationships, etc. But when you have any type of estate, own a home, um, investments, all that sort of thing, um, again, there's just no provision for the care of children. So by default, what would happen with no will is the children would just be left to everybody else who's here to figure it out. But with a will, you can provide for the children, any other dependents for that matter, in terms of who's supposed to take care, which schools they're supposed to go to, education funds, real property, all those sorts of things. So what's called the Succession Law Reform Act really deals with the priority in terms of who is supposed to get what.
Right.
So in your scenario, Keisha, as you presented it, if something was to happen to the mother and the father, obviously everything would resort to the children. But how is that going to be administered? Who's going to make those decisions? And that again now would fall to the courts to have to assign somebody there if the children are minor.
Right.
And then again, a lot of assets can be misplaced or misappropriated or not dealt with in the way that the parent would have wanted. So it's not a good thing, especially when you have dependent children, to leave them with that lack of structure, guidance, or intention.
Right. That is so interesting. I didn't even know that, like, within the will, you can, like, have instructions even to, like, where they go to school and things like that. So that's, actually even quite insightful to me. I'm curious if we can just sort of, like, break it down really simple. What is an estate? What does that mean? Because some people don't even know what I have an estate. They're thinking like Michael Jackson. I'm not Michael Jackson. I don't understand. So
the size of your estate is one thing, but everybody has an estate. Your estate can be something as small as the few little things you have in your pocket, to as large as your assets, your investments, etc., etc. So an estate is really the gathering of all the things you own and that you owe as well. Debts and assets.
Own and owe. Right. Okay. We need to talk about that.
I hit something there, didn't I?
Yes. Yeah. People don't think about that. What is owed. Okay.
Definitely,
so what you own and owed. I love it. Okay. Yeah. Like, I'm seriously taking notes.
Yeah. So that's pretty much what an estate is. And again, like I said, an estate can vary in size based on whatever you've owned throughout your life.
So then when you mentioned, I'm sorry guys, I'm so curious. When you mentioned varying in size, there is a term that people may have heard, probate, and I know that there's some rules around that. First of all, what is probate? But I know that there are some differences of like treatment or requirements, related to probate and the size of your estate. And that's good to know that everyone has an estate. Everything that they own is their estate. So yeah, if you can help shed light on that.
Right. So probate is a complicated procedure in terms of going to the courts, probate court. But in really executing the intention of a will, I think is really where the essence of probate lies. If it's done outside of court or within court, speaking to the size of an estate, you really have to consider whether taxes are owed, how debts are supposed to be dealt with, etc., and who is supposed to take responsibility for that. And that's really at the essence of what the probate process really deals with, based on the intention of the what we call the testator, which is the person giving the instructions through the will. So, for example, speaking to your question of size of the estate, estate administration tax, for example, is only applicable on estates that are worth more than $50,000. So $50,000 and up, estate administration tax is applicable.
Okay.
It's interesting because when I went to school, estate administration tax was applicable on the first dollar. So they've changed it and gave a little bit of a leeway in terms of smaller sized estates, and it's a lot more fair. However, to many of the viewers or many of the people ingesting this information, by the time they are ready to do or deal with their estate administration tax in terms of its applicability might change by then as well. So it's good to really keep an eye on that if you're engaging any comprehensive estate planning. And to go a little bit off on the side with respect to the probate and estate planning and trying to predict how your estate is going to be dealt with, there's lots of ways in which you can administer property or assets during your lifetime to avoid the application of estate administration tax, which is, and these are all legal things.
Yeah.
Anything that's, not within the context of what's legal, but even just, employing yourself with something that's called the right of survivorship, which is, allowing somebody who you want to pass the home to, upon your passing, to be on title of the home before you pass. That's a way of avoiding or dealing with estate administration tax. Assigning proper beneficiaries to your various insurance, life insurance, and different investments you might have. A lot of these things are ways to kind of strategize and reduce the, as we were saying, what you owe upon your passing. So I hope I didn't. I know I answered your question, but I think I went off a little bit.
No.
But
it was good information. Like when you said that 50,000, does that mean that if you have less than 50,000, you don't have to pay any estate admin taxes? Is that what it means?
That's correct. Estate administration tax. There may be other taxes you might owe on the CRA in terms of what income generated, all that sort of stuff, personal income tax, but estate administration tax is not applicable on the first 50,000.
So state administrative tax. What specifically do you mean by that? Like it's an administrative fee that you have to pay for somebody to handle it, or?
Yeah. So an estate administration tax is tax that's owed on the distribution of an estate after passing. So when assets are transferred by way of a will or other intention, there's a tax that's charged on the value of those assets that change title due to your passing.
Right.
And that's when estate administration tax is applicable. I don't have the exact percentage right now. Don't quote me on the percentage, but it can be quite extensive depending on, of course, the size of your estate.
Right. Yeah.
And it can take time, right?
In terms of dealing with the estate, Yeah, it can, because I mean, depending on the effects of your estate, you might have to liquidate, you might have to sell, you might have to transfer, you might have to wait till your Canada Revenue assessments done in terms of determining what's owed to the government. There's so many factors that come into play.
They got to
There
get
might be
theirs.
They're the
They
first
definitely
creditor,
do.
man.
They
there might be
definitely
disputes between family members as well too, right? Where
exactly, that may have
yeah.
to be resolved, right?
Hmm.
There are. I'll give you an example of where, based on a dispute, estate administration tax can be affected. Life insurance that has a beneficiary to it is not, estate administration tax is not applicable to it. However, um, if there's, for example, like Keisha was outlining, dependent support claim, meaning that you might have minor children, but you've left your life insurance to somebody other than your minor children, but your minor children still need support.
Mm.
The legislation allows for, by default, a dependent support claim on behalf of those children in the interest of that uh, life insurance policy. So that whole
Hmm.
situation could, of course, delay, as Keisha was saying,
Right.
the proper administration of the estate. I have a file right now that's been going 2 years after death, and we still haven't come to a resolution on that yet. So, yeah, it can definitely put a damper in what we're trying to do there.
Wow. I
Wow.
heard
But
of
but
stories. Go
yeah,
ahead.
but again, I think it's just really, um, you know, as financial planning, asset management, um, and estate planning goes along with all of those things. It's really good, and just as much as we deal with the tax burden from financial planning and asset management perspective, um, it's as equally important when we're dealing with our estate upon our passing. So all of them go hand in hand.
Right.
In
Yeah.
in terms of I was thinking here of our community.
Hmm.
I don't want to make a blanket statement. I may have some ideas in terms of how we are, based on my experiences, but it doesn't mean it's the same all
Hmm.
across, right?
Right. Right.
But based on some of the things that you've said so far, and all the descriptions that you've given to us, and even that scenario that you just briefly mentioned there, what's it like interacting with our people,
Mm.
our community, as far as this particular issue is concerned?
Hmm.
Are we oblivious? Many of us oblivious to it. Do we not take this into consideration? Maybe maybe you haven't had that type of interaction to give me full answer, but just shed some light in that area.
Yeah, that's a
Yeah,
good
that's a
Good
question.
question.
yeah, that's
Yeah.
a very good question. I've had a variance of experiences. I've had experiences ranging from uh, just dismissiveness with respect to, or that's caused by the wealth gap that our
Mm,
community has experienced.
Hmm.
Um, Unfortunately, there may be individuals from our community that may not have had the opportunity to generate wealth, and therefore estate planning is not really something that it's dismissed to them. It's not really something that they've considered.
Hmm.
Um, I've also experienced situations where, the wealth gap is not really an issue. That's not the issue there. It's just not something that's really talked about or really understood to an extent that it's needed. So breaking down that barrier to really explain that has been something that I've been taking part in with all my clients. And then there's quite a few people in our community that I've experienced that understand the importance, and really want to get going with it and making sure that it's put in place. At what point in life they do that is I don't think anything that's specific to our community. I think that's very general across the board. I think there's some people that, depending on your perspective, understand that it's something you might want to do very young. A lot
Hmm.
of people might think it's something that I'll do once the risk of that is greater. The risk of passing is greater, meaning old age. Um,
Mm-hmm.
and another thing is sometimes people's lives are so up in the air in terms of relationship, having children, generating different assets, etc., that they feel like their estate, quote unquote, is maybe not complete, and therefore they're just not ready to do it yet. So to answer your question more specifically, I've had a variance of experiences in our community. Definitely have had some that are specific to um, our community, just not maybe not understanding it, but also just your general reluctance or dismissiveness.
Mm-hmm.
Yeah.
Do you find that within our community, that the mindset is starting to change? I don't know if for any of us here was this ever a topic at our
Nope.
table.
Nope.
Most
Yeah,
definitely not.
yeah,
Nope.
Right. Right.
It was more, from my experiences growing up, no, don't talk like that,
yeah,
something bad might happen. A lot of it is based on
Right.
yeah.
superstition and all that, but
Yes.
it was never a topic of conversation. Sort of like from our community when it comes to issues of like even sex, right? It's very, very conservative. Usually we don't talk to our children and they go learn about these things on the street corner, right?
Hmm.
Right. Right.
Yeah,
As
because
a as a sorry, go ahead, Keisha.
so I was just going to say quickly, as I mentioned before, when we're covering the insurance, I mean, with my mindset at the time, I thought the minute I get life insurance, something's going to happen.
Right.
You know,
Right.
so, these are the type of things that, you just don't really entertain it too much because you have a negative thought towards it, right?
Right. I think professionally in my legal and my business and legal career, I haven't really experienced much of that type of resistance.
Hmm.
But within my own family unit, that resistance has been the primary resistance that I've experienced. It's like, want to deal with it when we're gone, kind of
Yeah.
thing. You know? It
Yeah.
hasn't, yeah, it hasn't been a thing where anybody's trying to say like, "What do you mean? I don't want to plan for my passing." Like no, we don't do that.
Hmm.
Um, so I'm assuming all of us have experienced that in our own family unit.
Yes, sir.
And the
Yeah,
drama.
exactly. The drama that ensues,
Drama.
um, even the
Family
thought,
breakdown.
Oh
exactly,
gosh, yeah,
exactly. The
yeah.
thought of having to choose who you're going to leave things to
Yeah.
brings a notion of preferential treatment where I think
Mm.
and not only our community, I think a lot of other communities have the same
Yeah,
view.
yeah.
True.
But it's there's a reluctance there, right? And then again, we have some families that, you know, are in that state where they specifically want to have a will because they want to give preferential treatment. So
Mhm.
um, there's both sides to the coin. But definitely in my experience, I've dealt with more of the, you guys deal with it when I'm gone. I don't want to think about that now, kind of thing, right?
Yeah.
Yeah.
I don't know. I just seen so much stuff happen like within
Yeah.
family. I've even consider like my own grandmother and things that have happened as assets are transitioning, or and the battles that'll go
Mhm.
on. Even if there is a will,
Yeah.
Yeah, yeah.
Yeah.
even with
Yeah.
the will, people are like, so and I think it's even harder if there isn't a will, because the whole thing I just sort of think is like you being able to leave your instructions of what you want to happen when you're not here. You don't want other people making that decision for you,
Right.
whether it's your assets, your children, like children first and foremost, and then your assets and things like that. So I think that having something in place, and I'm just even sort of seeing some of the stuff that I've seen. I'm even thinking that it's actually okay to have a conversation about it.
Oh,
I mean,
100%.
even if it's a kid, you're saying, listen, you get nothing. It's
Right.
like, you're not getting anything because you don't do anything. So then it gives them an opportunity to change
Right.
while you're here
Right.
and start to do something. You know what I mean? Like, it just gives me, because then they go through life, they don't do anything, they get nothing, and then there's all of this. You basically pass all that on to your kids to deal with,
Right.
Yeah.
Right.
and you're not here. So,
Exactly.
Yeah.
There's and just to build on our conversation to this point, if I may,
Yeah.
and this is one thing I'm noticing far too much, and it's actually a little bit, I shouldn't say alarming, but surprising to me. The will is not the only way in which your estate is dealt with. Um, when you are no longer able to make decisions, whether you're still here with us or not. Obviously, you can't make decisions on your passing, but there are certain circumstances when you still have life and you still legally own, uh, the effects of your estate, but you're just incapacitated to a point where you can't make decisions on
Right.
those pieces, and that's the power of attorney.
Power of attorney. Yeah.
There's two types of power of attorneys. One being the power of attorney of personal care, and two, the power of attorney for property. Um, they both do exactly what they're named. One deals with your personal care, meaning your healthcare needs, whether or not you want to be placed in a nursing home, or you want to have home at home care if your estate, the value of your estate can provide for that. Who's supposed to make the decisions on your healthcare or your personal care? And the same thing for your property. How your property is to be dealt with, what aspects of your property are can be liquidated to provide for your personal care, all that, and who's supposed to make those decisions as well. Even which is a very important part that I find a lot of my clients are very concerned with is life-sustaining treatment, which addresses when you may have entered a vegetative state or a state to which the only way you're able to stay alive is by medical equipment, medically assisted equipment. So power of attorneys can address all of those things, and I think that a good comprehensive estate administration strategy includes power of attorneys that transition you through that unfortunate part of our life where we may have experienced health concerns to where we can't make those decisions for ourselves, right through to our passing and what's supposed to happen afterwards.
Right.
Right.
Yeah, so good you touched on that.
Yeah, take us for someone right now who's watching, and maybe the light bulb has turned on, and they decide that actually I don't have a will in place. What's the steps? What is the process? Right? Take us through that.
Yeah, so the process in drafting these documents is really first and foremost to find a legal professional you feel comfortable with,
AKA Carl.
yeah, exactly. I'm here for you guys.
I'll
Don't
shout out for you, brother.
You're
Don't worry.
right.
I'll shout it out.
Shout it
Thank
out,
you.
boy.
worry. Thank you very much. And that really, finding a proper legal professional sometimes is as simple as finding somebody who understands even your cultural backgrounds, where you are from, the things that you're concerned about, the thing, being able to really source your frame of mind to really understand what should be important, what is important to you, and what should be important to you. And once that process is complete, it's really helping to develop a list of the aspects of your estate, assets, debts, all that sort of thing. Obviously, children and whoever else you might want to take care of, or you currently take care of. That meeting is very personal. It's very impactful. It builds a connection between the legal professional and the person that wants to have those documents drafted. And then we get to the drafting stage. Your legal professional should be able to suggest and recommend ways in which things are dealt with that you might not have thought about. Excuse me. And that's really, excuse me,
Bless
your
you.
main concern in terms of picking the right person to help you with that.
Yeah.
I do have a question because because I mean you've been talking about getting a professional, but there are people who are like, I need to do this stuff myself. We talked about that in a number of other areas, right? We're like self-serve. I'm going to do my own research. I'm going to save on costs. So what are your thoughts about that? Because there's things like a will kit out there.
Right.
Yes.
Can you do it yourself? Is it valid?
Right.
What are the
So
risks?
it is
Yeah.
totally acceptable by Canadian law and other jurisdictions to draft your own will. There's different ways in doing that. There's just requirements with respect to witnesses, but people can still draw your own will by yourself, and it still provides your intention, to which if your estate administration is challenged, at the very least, that's something that can be brought to the court to demonstrate your intention.
Even if it's on a paper napkin.
I was
Even if it's on a
thinking,
paper
I was Billy Jane. I was just about to ask that because I've seen these little scenarios where somebody hurriedly wrote something on a piece of paper, and I mean
Yes.
that is binding.
It's
if it's witnessed, I guess.
it's not so writing on a piece of paper is not obviously as strong in terms of its bindingness as a will that's been witnessed, stamped, and has your proper affidavits and all that sort of stuff is required under the legislation. However, the essence behind the law is to uphold the intention of the testator, which is the person leaving their effects of their estate. So anything that demonstrates your intention will be held paramount. And that's what is at the essence of wills and estates law. So yes, somebody drawing something on a napkin can definitely very well be upheld in court. And we've had case law. I mean, this area is one of the most interesting areas to read case law on because the types of situations. I mean, I've in the UK when I learned, this area, we had situations where, last minute people left 99.9% of their estate to their cat, and it's dealing with how does that even apply to a cat, and is it valid, and all that sorts of stuff. So and these things are written very loosely and not in a proper will. So it can be a very sticky situation. But
leaving it to your cat. Stick it to the kids.
Right, I was about to say that's just them getting back at kids, right? Or
sticking it to the kids.
And it can be that contentious at times, right?
Wow.
I'm sure you see so many interesting cases, like especially with affluent family. Like I've heard of cases where, they get remarried 2-3 times and they're saying they want to leave this to this. And then the first wife or the first set of children, they're battling against this. And, I can see it keep getting really hairy, especially as you have more complex estates.
Right. And that's something that I really like to hammer down on. I think it's always good for throughout your life to have a lawyer that even cannot be asked questions to or consult with, because along the way we always need to know how the law affects us and how us dealing with ourselves and our property through our lives can have legal implications, right?
I love that.
Other communities do it all the time.
Yeah, no, but that is, really showing that value add beyond just writing on a napkin or just doing a will kit. There is, incredible value of having a professional help you through this, right? And help guide you and help even, because sometimes you may think certain decisions, but you're not aware of other kind of scenarios, things like that, right? And so exactly. I think there's significant value of having, a lawyer counsel help you, like really counsel you through that decision from power of attorney to the will. Right?
Excellent. I agree.
I am curious to know, I have a question about the executor.
Right.
And okay, well, first of all, even I loved what you were saying about like the will. So the will shouldn't, the way that I'm thinking, it shouldn't be a one and done thing. You should be revisiting your will throughout your life as your circumstances are changing.
Definitely.
Because that's something that I'm thinking about. I'm like, I need to go and get that revisited. So I'll be calling you, Kyle.
Okay. I look forward to it.
Because I'm like, we set it up, before, and we try to think forward, for however many children would come. But, I think that we need to reassess that. So thank you for that. It is a journey. But in terms of the executor, who you assign, like I was talking to a lady who said that her brother had transitioned, did not have a will.
Right.
Things were in a huge mess. And it's like I don't know if it went to the courts and they're trying to assign an executor or wanting to assign it to her or something. And she was saying that she would be responsible financially to the taxes and stuff. So I'm curious to know your thoughts around assignment of executor, what it means, like if there's no will and you assume a role of executor, like that kind of stuff.
And should you have a backup executor in case that
one
is on or something?
Yeah.
So that's a very good question. because there are definitely situations where an executor could potentially be liable, especially
Wow.
if there's misappropriations, misdealings that are obviously in bad faith. The law doesn't sanction for honest mistakes,
Hmm.
so that's one thing. But there can be liability where there's malicious intent and recklessness, in terms of administering an estate. Um, it's always good. Well, obviously, if you have the documents drafted up, you would have assigned an executor. I always recommend for backup executors if they have them. And that's something that I like to go through with my clients, because they might have somebody off the bat who they're thinking of, but based on the requirements of executors, and the need for the executors to really understand them as the client, or the person who the will applies to, is important. And that being said, I always advise against anybody who's a power of attorney or an executor to be also a beneficiary, because
Mm.
there's definitely conflicts that can arise there. Now, obviously, I, in some of my recommendations, those types of recommendations, the client has come back and said, no, 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 we don't have to worry about that. We're okay. Still, even though they're a beneficiary, still leave them as an executor. And there's other times where they're like, oh, you know what? That's true. If they're going to benefit, I don't want them having decisions over how my healthcare decisions while I'm still here. Um, so I always recommend it being a neutral person, and that's with a will. Uh,
Yeah.
but even before I elaborate a little bit more on that, we'll go to without a will. Without a will, there are instances where an executor or somebody can act as an executor. However, you may encounter barriers with different organizations, banks, if you want to get bank accounts, if you want to transfer property. Sometimes the lawyers will say, okay, no, we're not going to do this. And then what you need is what's called a certificate of appointment of a state trustee. And what that is an application that's drawn to the court on behalf of whoever's trying to apply to be an executor, um, to assign and declare that that person is executor. And then you get a certificate, and that's legally valid, and nobody can deny you access to deal with things from the estate once you present that. So there's something similar as well for power of attorneys, where the courts can assign somebody as power of attorney if for some reason there's contention on who wants to make the decisions and who's better able to make decisions as well. Um, so that's always something that's something I help clients with as well, and something that usually, sometimes has to happen, but not always. It's not always needed. Um, so in terms of executors, in terms of also, the legislation also provides for compensation for executors and reimbursement for executors to certain capacities. I don't remember exactly off the top of my head, uh, you know, the equation for determining compensation. But that's something that can also be provided for and is legislatively permissible. Um, so I think it's safe to say, and I always advise my clients that when they're assigning somebody as an executor or even a power of attorney, that they can provide for compensation and reimbursement, etc., from the estate.
Mm. That's a good point. Just because the other thing that I was thinking, or I think I got some awareness about, is also even considering where the executor is. Like sometimes people will choose an executor who's not even in the country, and not
Mm.
thinking about all of the administrative work, like timelines, like somebody has to be here or to sign or whatever. Like those kind of
Right.
things can also complicate things. So to also consider that and figuring out
Hmm.
who you
Yeah.
want to be your executor.
And
Definitely,
that
and
could
and,
be.
and yeah. Sorry, go ahead, Keisha.
Oh, sorry. I was just going to say that could be a situation where, in revisiting, because maybe at the time that executor was in the country, that executor has moved out of the country now, and that's just been sitting there and didn't really think, oh, I need to assign a new executor. Yeah, and then something happens, like, oh, yeah.
Exactly, and so anybody in the world can be an executor.
Hmm.
Um, whether they're here doing it or somewhere else doing it is a different question. Because it's, you know, access to be able to deal with things and present yourself and all that sort of thing. But that's definitely something to think about, because that could be costly for an executor. You know, flights, accommodation, time away from work, all that sort of thing, right? So it's always better to have somebody local. But you know, people coming from the Caribbean or anywhere else, that might not always be the case. I actually had a client recently who had absolutely no family in Canada. He's only been here about 5 years, well, other than his children. But he didn't want to leave his children the responsibility as executor because they're going to be beneficiaries. And he assigned one of his children that were in another country. So that person is going to be tasked with having to, you know, deal with the estate administration from overseas. So sometimes that's just how it has to be. But definitely, in if that's how it has to be, then considerations for the facilitation of that, whether it be reimbursement, compensation, etc., is something that
Yes.
should definitely be considered. And why that's an important point too is because you can refuse to be an executor. You don't have to be. You can't. Nobody can force you. So if you really want somebody to take on that responsibility because you think they are the best person, you don't trust anybody else, then you really want to make sure that things are provided for in a way that, you know, helps facilitate them making that decision very easily, right?
Yes.
So you should be. Yeah, go ahead. Sorry.
Yeah. I just wanted to remind us that Keisha has to go soon. So,
Yes.
in terms of the situation that you just described, somebody being the executor and they're elsewhere, right? What if you have a will set up, like just say in Canada, and then you've moved to the US, and and let's just say you set up something over here. How does those two scenarios play out? Is there one is not important anymore, or?
That's a very, very, very good question.
And over there in the US now?
Right? Personal.
That's okay. That's okay.
That's a good question.
It just came out of the air somewhere.
That is such a good question.
Yeah, and I mean, as it may be of your personal experience, I mean, that I think is going to be an experience for many, especially in our community, being you know, descendants or actual migrants from other countries. So there are treaties with various countries that provide for the validity of will in one country being valid in another country. It usually is something that would have to, well, not always, but it can be applied to the court to determine whether or not the will is valid and consistent. And the court can make a determination whether or not they're going to uphold that particular will if it's from a different jurisdiction or not. But the way wills are drafted is, and I've come across so many situations where there was a previous will that's drafted, but they can't find it. And so it may have been filed with the court. They can't find their own copy. They don't even remember if the lawyer filed it with the court or not. So if you're going to draft a new will to cover any will that either you can't find or is in another jurisdiction, can't get a hold of the lawyer to get a copy, a new will can come into place and basically declare all other wills invalid. So that's a way of addressing that type of situation. But yeah, wills from other jurisdictions can be upheld, and will usually be determined as such by a court of competent jurisdiction.
All right, Keisha, give us a cue. I mean, we can start winding down.
Yeah, for sure. So definitely, I think we have to, there's many different avenues that we can go with Kyle. So I would love to, designate another session with him, especially where even real estate is concerned as well, right? So we're here to give knowledge and opportunity to those in our community. That is why we're here, and we want to continue to do that. And we know that, of course, wills is something, not just our community, but overall, it's something that's just neglected. People don't, they don't feel comfortable doing it. So we want to make sure that we're putting the information out there that even if it be one, that you're able to grab onto this information and start taking steps, right? We're trying to change the dynamics here, right? We are trying to create, generational wealth as well. And these are some of the gaps that are in place when we speak about even life insurance and not having something set up that can pass down to your children that will help them out, right? It's not about the money. It's about positioning them, to step out and, do greater things, whether you're here or not here. So we want to really thank you, Kyle, for taking the time to come and sit down. Where can anyone reach out and contact you if they're looking for simple answers to simple questions or to use your services overall?
Thank you for having me, Keisha, and I appreciate that. I can be reached. My social media presence is very scarce at this point in time, but I can provide my email, my phone contact, as well as I can be found on the Law Society of Ontario website for anybody that wants to check my credentials and determine whether or not I'm there. But that's what I usually provide to people. But definitely my social media presence and my online presence will be ramped up shortly. But as you can see, I see that my email's been posted in the comments, so I can be reached at kyle.corbin@corbinslaw.com. And I'm hoping that any of you that come across any referrals can direct them my way as well. So I really appreciate the opportunity to be here today and to assist in educating people in generating that generational wealth and closing that wealth gap. So thank you very much.
Don't worry, brother. It's coming. It's coming. We just needed to find you. We just needed to find you. That's it.
Thank you.
We were having that conversation, man. Who?
Thank you. I appreciate that.
Now we know.
I appreciate
All
it.
right. If we'll talk offline, if anything, because you have a lot to say and we want to hear it. All right, folks. So we will connect next Thursday as we continue to help you make this is Wade's part now. Sense of your dollars, all right?
Yeah.
From Billy Jane and Keisha, Wade, who's not here, and Mr. Kyle Corbin, we thank you very much for watching and for viewing us from week to week. If you want to reach out to us, just hit us up. We're on Facebook and YouTube. All right, take care until next week.
Thank you. Take care, guys.